Hello everyone and welcome back to the channel. Hope you're all keeping well, and thanks for all those who have been subscribing so far. It does really help for those who do subscribe to help grow the channel and to expand some of the content that we produce for the Barrister channel. So welcome back, and today we're breaking down what actually happens at the first hearing in a criminal case. This is chapter 3 of the Criminal Litigation Bar Course series, and for those of you who haven't watched the previous videos, do recommend you go back and watch those. So chapter 1, looking at an overview of the criminal justice process, and then the last video, chapter 2, we looked at the first elements of a case. So police powers, pace, when you get arrested, when you're taken into custody at the police station, the interviews, and then also the charging decisions. So after being charged, sometimes you're summoned for a first hearing. So whether you're a bar course student preparing for the criminal litigation exam, or you're a member of the public who just wants to understand what really goes on in court, in the next few minutes we're going through the process step by step. So which court deals with what, how the plea before venue works, how the court allocates either way offences. Again, if you go back to chapter 1, the first video in the series, we explain a little bit about either way and also summary only offences. And then also we're going to look today at when cases are sent to the Crown Court under section 51 of the Crime and Disorder Act 1998. What controls bail under the Bail Act 1976, and how the criminal procedure rules, especially Rule 1.1, the overriding objective, shapes everything that happens at the very early stage. Just a reminder then, this is intended mainly for bar course students, but an insight for the general public. It's not an extensive revision tool, it's just a snapshot and overview of the key concepts. So let's dive in to slide 1. So the first hearing. The first hearing takes place always in the Magistrates Court. That's true for every single criminal case in England and Wales, no matter how serious. At this stage, the court is focused on two main things: case progress under the criminal procedure rules, and the defendant's rights under PACE and Article 6 of the European Convention on Human Rights. So the court wants to identify the issues as early as possible. That's part of the overriding objective in Rule 1.1 of the criminal procedure rules, dealing with cases justly. Just for the general public, criminal procedure rules are like a guidebook on the different procedures that need to be followed during a criminal case. So Rule 1.1 includes fairness, efficiency, and making sure the defendant understands the process and can participate effectively. So you must be thinking, which court then? The jurisdiction. We touched upon this during chapter 1 in the first episode, but all cases start in the Magistrates Court, but they don't all finish there. We have 3 types of criminal offences, as a reminder: summary, either way, and indictable only offences. Summary offences stay in the Magistrates Court. Indictable only offences get straight to the Crown Court, get sent to the Crown Court rather, and either way offences could go either direction depending on the plea before venue and allocation, and we'll look at that now. So the plea before venue, or PBV, for either way offences, the court starts with plea before venue, and this is where the defendant is asked to enter a plea before allocation is decided. So if the defendant pleads guilty, the magistrates may sentence or they can commit the case to the Crown Court for sentence if they feel that the sentence exceeds what they can safely give according to the rules. If the defendant pleads not guilty, however, the court moves to allocation, and we'll look at that on the next slide. Just remember, PBV is for either way offences only. Indictable only offences skip this step entirely, and they go straight to the Crown Court under Section 51 of the Crime and Disorder Act 1998. We'll come back to that in a few slides' time. So at allocation, the court applies the allocation guidelines and the criminal procedure rules to decide whether the case should stay in the Magistrates Court or go to the Crown Court. The court considers seriousness, complexity, and sentencing powers. So even if the magistrates accept jurisdiction, the defendant can elect trial in the Crown Court unless it's a summary-only offence. And I think I mentioned this in Chapter 1, the overview section. Some defendants may feel that rather than some lay magistrates deciding on their fate, if they go to a jury trial in the Crown Court, they may have either better sympathy or more understanding from 12 general members of the public in the jury. But that's a matter for the defendant to discuss with their legal representative as to the best strategy available. So summary offences are for lower level matters, and they are only tried in the Magistrates Court. Sentencing powers are lower, procedure is streamlined, and there is no jury. This is the simplest category. Indictable only offences are cases where they are more serious. It's the serious ones. So think of murder, rape, manslaughter. These are automatically sent to the Crown Court under Section 51 of the Crime and Disorder Act 1998. There is no allocation and no PBV. They go straight up. We will look at bail in particular on the next episode, Chapter 4 of this series, but briefly here, at the first hearing, the court must consider bail or remand. And the starting point is the Bail Act of 1976. The prosecution may oppose bail, but the court can only refuse bail on specific grounds. For example, there's a risk of failing to surrender. Maybe they've not adhered to bail before. Committing further offences, there could be a risk of society, doing further similar offences or other offences, or even interfering with witnesses, as set out in Schedule 1. The defence should always address those risks head-on and offer conditions where necessary, but bail decisions can have enormous consequences even at this very early stage of proceedings. Early disclosure supports a fair trial under Article 6 of the CHR, and the prosecution must provide initial details at an early stage. Disclosure is not a one-off event. It's an ongoing duty. So this comes from the Criminal Procedure and Investigations Act and is reinforced later in proceedings by the Criminal Procedure rules. Every defendant has the right to legal advice. A duty solicitor is available at the Magistrates Court, and representation ensures the defendant can participate effectively, which is a requirement of the overriding objective and of Article 6. Without representation, justice becomes much harder to achieve. Everyone needs access to a fair representation via a solicitor or other legal representative. So once that's happened, case management takes place. So now the court uses its case management powers to keep proceedings efficient, fair, and focused. The criminal procedure rules, and especially Rule 1.1, the overriding objective, require early identification of issues, active participation, and avoiding delay. The court can also make directions to progress the case. So what happens next then? What happens after the first hearing? Summary cases move forward to trial or sentencing in the Magistrates Court. Either way, offences will be heard in the Magistrates or the Crown, depending on allocation. And indictable only offences go straight to the Crown Court for the next stage under Section 51. So that was just a brief overview of the initial process of the first hearings for a defendant. If you do have any questions, drop them in the comments below, especially if you're on the bar course and want help with criminal litigation, evidence or procedure. And if you did find this breakdown useful, hit the subscribe button and stay with the Brum Barrister community, because in our next episode, we're moving on to the next stage of the process, which is the plea, trial and case management hearings in detail, otherwise known primarily as bail, we're going to look at. And this includes real strategy behind each stage. So once again, thank you for watching. We do hope you enjoyed that. Please subscribe if you can, and we hope to see you on the next video. Bye-bye for now.